I now call case number 112056 in the matter of Timothy H. Henderson. Before we proceed, I'd like to elaborate on a comment I made at the beginning of all oral arguments this morning. That is, Justice Marla Lukert is recused on this case. Sitting in her place in her chair is a distinguished jurist to my right. This is the Honorable Joseph McCarville, who sits as a district court judge in Reno County. He has read all the materials and he is ready to participate in oral arguments and also the final resolution of this case as we conference later this afternoon. Judge McCarville, on behalf of my colleagues on the Supreme Court, I want to thank you for helping us out today.
I'm glad to be here. I'm looking forward to participating.
Very good. Now have counsel with arguments.
Good morning. May it please the court, I'm Todd Thompson. I am the examiner for the Commission on Judicial Qualifications. We are here pursuant to Rule 623, which requires a mandatory appearance by a judge who has been subject to a panel recommendation for discipline, as is the case here. On July 8th, 2014, one of the panels, Panel B of the Commission, issued findings of fact, conclusions of law, and a recommendation regarding Judge Henderson, the respondent. That recommendation was for public censure. The findings and conclusions are not at issue in any way here today because Judge Henderson filed a statement with the court saying that he was not going to take exceptions to the findings and conclusions and was not requesting to make a statement or a presentation. So the issue today is merely for you to pass on the recommendation by the panel of public censure. And in light of that, unless the court has any questions, I have no further presentation.
I'm curious of how the mechanism that the panel employed to find the appropriate sanction. How did they arrive at public censure? Do you know?
The panel conducted an evidentiary hearing. The rules of evidence apply. It's a full...
Yeah, I understand that. But
okay.
Then I assume they deliberated and arrived at a public censure. Do you know how that occurred and what they considered? Or what guidelines
I was not privy to that. It is my understanding that they conference, not unlike this court conferences after hearing arguments. They heard the evidence and then conferenced to discuss that. They circulated a proposed draft of the written findings and conclusions, and it was ultimately, as edited, was unanimously agreed to by the panel.
I think part of what the question entails is that on our disciplinary cases for attorneys, we'll have the hearing panels will provide us with ABA standards on discipline, recite several of those, go through a rationale why this is preferable over this in this particular case, and in this report it's basically page after page after page, and then we get at the end, therefore we say public censure. So we don't really have a lot of insight into the thought process of applying those findings of fact to the discipline like we're used to seeing. So I think that's where the question comes from.
I would love to be able to shed some light on that. Unfortunately, since I was not privy to the panel's discussion or participated in any way in their deliberations or the drafting of their findings and conclusions, I don't know the answer to that.
In your role as an examiner, you don't make a recommendation to the panel as happens in disciplinary cases?
I did not in this case, that's correct.
Okay.
I did not present the evidence in this particular case.
Oh, okay, thank you. Did the respondent make a recommendation?
To my knowledge, there were no submitted findings and conclusions or recommendation as to a sanction.
Thank you.
Can you tell me how public censure protects the people who will be doing business with the 18th Judicial District from the behavior that we have to consider conclusive from the panel's findings?
I would suggest in the same manner that public censure of an attorney protects the public, the hope being obviously that upon being censured, A, people have become aware of that history, and B, that the conduct is curtailed. Because, as is typical, the second bite at the apple is typically not as favorable in terms of the punishment imposed. So there's an interorum effect, if you will, of the public censure being on the books.
If you were the attorney for the judicial branch and we brought these conclusions to you and said we have this employee that's done this and admitted it, particularly I'm really talking about the behavior with the women, how would you advise us to protect future women doing business with the court system?
I look up at the panel here and I'm a little hesitant to give legal advice to this particular group.
You do it all the time. I mean, I used to do this, and I think I know what the answer is.
The ultimate protection is to remove the public official from that public position. Then that leaves no doubt. There are steps in between, such from public censure to requiring counseling. There are a number of steps that could be undertaken there to try and accomplish the same goal. But ultimate protection would require removing the official from the position.
And you do not have a recommendation for us other than this is what the panel's conclusion was?
Correct. Under the rules and the code for the Judicial Qualifications Commission, it is the panel that makes the recommendation to you.
Well, I was responding to Justice Biles' inquiry of you if you were our lawyer and we held a gun to your head and said, give us a recommendation. But you do not have such a recommendation for us today. You've just given us some of the alternatives that could be suggested.
Correct.
All right. Thank you. Any further questions? Any further presentation?
No, thank you.
Thank you, counsel.
Thank you. Please, the court, your honors. As I indicated earlier, I'm Thomas Haney. I represent Judge Henderson, who's here in court today pursuant to Rule 623D. I have no argument to present to the court. We have filed a statement that we do not take exception to the recommendation, which is for public censor in this matter. And beyond that, I have no argument per se or no additional comments to the court, but obviously if the court has questions, I'm here.
Why don't you take my question? Why is public censure the appropriate discipline in this case, given the allegations and the case law that we've got on judicial qualifications?
Your Honor, I guess you're asking me as an advocate for my client to answer that question. The best analogy I can draw is that this court's sanction should be adequate but not excessive. And based upon the record as it appears in this case, that public censure is adequate but not excessive. And no one can guarantee the future conduct of any individual based upon the hearing that was held, based upon the findings that were made by the panel and their recommendation. We think this sanction is adequate but not excessive.
Well, for example, the Robertson case was one where a judge used computer equipment in the privacy of his office in order to look at pornography. There weren't any victims. And the sanction there was removed. And in this case, we have victims. I mean, this is what I'm wrestling with. We have victims We have no dispute about the facts because you've taken no exception to them. We have victims who said that they were worried that they didn't report this behavior because they were afraid of retaliation, that this was a judge that was politically connected and vindictive. And then we move to the next count, which is the Martin Bauer email, and there's conduct where it is, I don't think you can characterize it any other way but retaliatory. So I keep circling back to how does this discipline, proposed discipline, protect the people who need to do business with the 18th Judicial District? And I am asking you this as an advocate. I mean, I understand your role here, but this is what I'm wrestling with.
Your Honor, I think that you mentioned that there are no victims in child pornography cases. I've given that argument for years, and I've always had the court say, Mr. Haney, there are victims in child pornography.
I don't know that this was child. I don't remember the facts. I know it was pornography.
Or any pornography case. It's not a victimless crime. But in this case, as the court, I think, used an expression in the last argument I heard, the proof is in the pudding. The Judge Henderson is still on the bench. His duties have been changed, but he is providing service as a judge in his district. None of these allegations involved his conduct in any case on the bench, his dishonesty in any matter, and centered upon matters which were comments in poor taste. Even I think Mr. Bauer testified that he did not take exception to the judge's treatment of him in court as a lawyer. And I don't think that any of the findings that were made by the panel affected or criticized Judge Henderson's abilities as a judge. And as far as retaliation, I can't control what the opinions may be of people, except there's nothing in this case concerning a finding or allegation of retaliation that had me meat to the bones.
So, Mr. Haney, let me kind of follow up from Justice Biles. It's pretty obvious as you read through this record, as I read through this record, that for a long time the victims or the complainants in this case felt that there was misconduct. They felt that they had a duty to report, and they also had a fear that if they did, either nothing would be done or they would experience retaliation even if something was done. And when we talk about the sexual comments to the assistant district attorneys, that's one thing, but also just with what happened with Mr. Bauer and the issue with the teaching position would lead an ordinary person to conclude that maybe Judge Henderson does use his power outside of just making decisions in the courtroom, which I don't think anybody's contesting. So what I took from Justice Biles' question was, as an advocate for Judge Henderson, what do you suggest as actual sanctions that can ensure that if there is misbehavior in the future, it's going to get reported or discovered, and we won't be just waiting for years for some other victims perhaps to have enough courage to come forward, especially if they see that really nothing happens other than just the publicity that's happened so far. And so they're kind of left there wondering, why did we go through all of this? That's a long question, I'm sorry, but that's the best I can do.
Your Honor is correct that these allegations go back some period of time, some of them years and years. I was surprised at all the witnesses that testified had recollections as to what happened so many years ago. But be that as it may, the sanction of public censure of a sitting judge is a serious sanction. There's no question about that. It's not a slap on the wrist. It's not a warning. It is a sanction which is authorized both by this court and by the legislature, and it's a serious matter. As far as the effect of that sanction, I know this court is not does read the paper and does follow what happens publicly in this matter. And Judge Henderson has been and continues to be the subject of media scrutiny, articles, and there is nothing in this record that indicates at any time Judge Henderson retaliated against anyone in this case. And who knows why these allegations were brought years and years after the fact. If something would have been said years ago, it might have been handled much differently than we're here today on a formal hearing before the Supreme Court.
Mr. Haney?
Yes.
Your comments about no evidence of retaliation obviously are confined to the sexual harassment allegations. You're not talking about the Martin Bauer situation.
I'm saying I don't find any record that there was what I would call retaliation.
Post-complaint.
Post-complaints.
Okay, I understand what you're saying now. We asked your opponent if he had any insight to provide to us on the thinking of the panel and its recommendation, and now I'm just going to ask you the same question. Are you aware of anything that we should be aware of on the panel's reasoning for its recommendation?
Your Honors, I think we're both in the same position. I was not attorney of record at the first hearing.
Mr. Haney, go ahead.
I was just going to say, I assume that the panel did what it was supposed to and reviewed and relied only upon the record before it and judging the credibility of witnesses. Anything extrajudicial, I assume, didn't come into the record that I'm aware of.
How does reassignment to a different position address the concerns here of the Commission and our concerns? It seems to me that the concerns are related to the capacity as a judge and the responsibility and trust that is placed in the position, irrespective of the assignment. So how does the assignment factor into our consideration?
Your Honor, I can't speak for the administrative judge in Sedgwick County, but I believe that the assignment took the judge out of daily contact with a number of the complainants. That relationship doesn't exist. There never was a complaint that I'm aware of made in this case that the judge did anything in any case which adversely affected the advocates in the case or the parties in the case. These were comments made off the bench.
Excuse me, sir. You've said that three times, and I just want to go back to make sure I understand the facts. Weren't some of the complainants in the sexual harassment count people who appeared before Judge Henderson as advocates?
Yes, but it did not.
And so how can we say that we know that their behavior before him as advocates was not affected by his behavior toward them outside the courtroom?
Your Honor, all I can look at is the record and say there was nothing made by any witness that said we thought anything that Judge Henderson ever said to us off the bench, in the library, whatever, affected any pending case or affected their presentation of any pending
Their
case.
performance. There's no direct testimony about that.
There's not even indirect testimony.
Okay,
I
thank
can
you.
find.
What about the request from assistant district attorneys to be reassigned so they wouldn't have to be appearing in front of Judge Henderson? Can't we at least infer from that those attorneys felt that they were not able to give their best performance because of Judge Henderson's behavior?
You could probably infer a number of things, but the transfer was by Judge Henderson to avoid any conflict or any future issues in that regard.
Well, as I remember the testimony, though, it was that a request was made for Judge Henderson to leave his position as head of the, I can't remember the title down in Wichita, but the head of the division or whatever. And he refused and didn't for several months. And then it wasn't until the complaint was filed, or it was about to be filed, and the district attorney went to meet with Chief Judge Fleetwood and said, either you do it or I'm going to file something to get a recusal. And then he left. I mean, it was not a voluntary act as I read the record. Now, am I misreading it?
Well, if a voluntary act means someone comes in and says, I volunteer to do this.
But I haven't got the facts wrong.
Judge Henderson
we refused to do it for several months, and then when it kind of brought to a head, however it happened, we decided we were going to leave.
Your Honor, I wouldn't use the word refused. I would say that Judge Henderson either declined or did not transfer. But when the administrative judge said, we want you to transfer, he did. It was that simple. So there was not a refusal to disobey the directions of any administrative judge or this court or anyone else.
Well, Mr. Haney, I'm not understanding the question the way you did, apparently. The question, I just understood it, maybe it wasn't stated this way, but what evidence is there that Judge Henderson recognized what he was doing was wrong and took any action to deal with that prior to the complaint being made public? I mean, my reading of the record is the first time that anything actually ever happened as far as him changing assignment or anything like that was after the complaint was made public. It seems that if he has any insight into what his behavior was doing to the people he was dealing with, then he would have taken appropriate action before the complaint was made public. So that goes back to my prior question about, okay, how can we be sure that he has the insight into why the stuff he was doing was wrong, and how to make sure that it doesn't happen again?
Your Honor, I think it's important to note that even though we're here today and have not filed exceptions and are not taking exception to the recommendations, that this was resulting from an adversarial hearing for the panel in which both sides presented evidence. And I know the panel has read the testimony in this matter, that Judge Henderson testified that he did not believe that he intentionally meant to offend anyone. And obviously that's the reason that we're here today, because the witnesses testified they were offended and the panel found it also. So
my question is then, if he didn't intend to offend anybody, in other words, he didn't know he was offending anybody, how do we deal with that? I mean, if he doesn't have enough sensitivity to understand that this was offensive and that the first hint that somebody might be offended take action, then why should we trust him to take care in the future not to repeat the same behavior?
Your Honor, this is an entirely different circumstance. The circumstance before went over a number of years, as the court has to remember. There was no complaint made until this complaint was filed. There's been an adversarial hearing, there have been witnesses presented, there's been findings made and a sanction proposed. So this is not a situation which existed 4 years, 5 years ago, and to say why didn't the judge realize what he was doing then was offensive. It's, to draw kind of an odd analogy, my father-in-law was a retired neurosurgeon for years, excellent doctor, but he was a doctor also who dealt with patients, not only his patients but his friends, and I had seen comments by him with patients that, "Doctor, you should not say that, either to a patient or to a waitress. Well, I didn't mean anything by it. You can't do that, doctor." And I think the same thing with Judge Henderson today, realizes that none of this was maliciously meant.
And Mr. Haney, given that position, what has Judge Henderson done? And if you can't answer this question, perhaps he can answer it for us if he'd like to address this. But what has he done since the panel hearing, other than be reassigned, which was not at his instigation? What has he done that would demonstrate to us the things that Judge McCarville has asked about?
He has obviously undergone and continues to undergo self-evaluation on this matter, and has discussed the possibility of sensitivity training through a number of facilities that are available. Nothing has been scheduled specifically in that regard, but he's aware that I wouldn't say being politically correct is important, it goes beyond that, but it's...
But he hasn't enrolled in any such training or sought any kind of
No,
counseling.
he's even discussed it with the chief judge in the district. So there are ongoing directions, but there was no recommendation from anyone that he does that, so it would be voluntarily on his point.
Counsel, did your client wish to address the court on this particular issue or any issues?
He takes the same position I do, but I certainly don't want to preclude him if he wants to say something to the court.
been a judge 14 years, and I, like you, have had people stand before me, and I know sometimes words can be very hollow, but they're still important to say. I'm so sorry. I said this at the hearing. I consider these people my friends. The fact that I hurt them breaks my heart. I've embarrassed myself, I've embarrassed my family, I've embarrassed my wife, and I've embarrassed the court. And everything that I've tried to do in the last 14 years to promote child welfare and juvenile law gets erased in that moment of stupidity on my part. Justice Biles, you asked, how do we know if I get it, so to speak? Once again, I can give you words, but I think actions speak louder than words. I have a wonderful administrative assistant. I don't want her punished because of my stupidity, because of my fault, because of my sins. Therefore, when a new judge was elected in August, I spoke to him, and he has graciously agreed to hire her so that she isn't affected by my poor decisions. I get this very well. I know everything I've worked my whole life for is at this moment in your hands. And I know how serious that is. I didn't want it to affect her. Now, I want to make sure I'm very candid with the court. Judge Fleetwood has agreed to have one of the clerks come up and serve as my administrative assistant with the understanding if I lose this position that she can go back to being a clerk. But I think by my actions I've indicated how serious this is. Regarding the therapy or any sort of intervention, Justice Beyer, I continue to meet with my pastor. I've spoke to a number of therapists about the facts of this case, provided the facts in this case, and they're telling me that's not a therapy sort of issue. I was asked to recuse regarding the assistant DAs in this case. I've not only done that, I recuse from anything involving the district attorney's office. Even though I'm in the civil department now, I had a forfeiture case came up that the DA was involved in. I recused myself from that as well. I don't want anybody in the district attorney's office to think I'm making any other decision based upon the facts and the law, because that is my obligation.
Judge Henderson, let me ask you this.
Yes, sir.
And I don't mean to be argumentative, but when did the light come on? And I say that because when the complaint was made, you filed an answer and it said you denied the allegations, and there was even one point where it said you emphatically denied another allegation, which I was trying to figure out the difference between the two. And then we go through a full hearing with these women victims having to testify, having to be cross-examined by Tom Burscheid, who I think is one of the better trial lawyers in Kansas. And it was a tough cross-examination. And then we get the findings, and then here at the end we take no exception, which is an admission of everything that's in this panel report. So I guess when did you, if you get it now, when did you get it?
I think the most honest answer is that it's a process. The day I was told this by Judge Fleetwood when he came out on Monday, September 23rd, I was stunned. I considered myself a mentor for one of the assistant DAs. I tried to help her career as much as I could because I think she's an incredibly good attorney. I was stunned. From that moment, as you probably read through the transcript, most of these conversations occurred in what we call the law library. I was never in that law library again after that moment because I never wanted to be alone or in that environment that is very bawdy, to use a term, dealing with tough cases. There's a lot of gallow humor there. And I just would not go in there anymore because obviously what I said, even if unintentional or taken out of context, was offending people, and I didn't want to do that. I had my administrative assistant in with me in my office at every time I was meeting with any staff at the district attorney's office because I never ever wanted again to be in a situation where somebody would feel uncomfortable in my presence. There was discussions between Judge Fleetwood and Mr. Bennett. Judge Fleetwood eventually came out and said, he did originally suggest I go downtown. He came out 3 days later and said, a complaint's going to be filed. I want you to stay out here. I believe I testified that at the hearing. I also take exception to what the media likes to report, that I was reassigned. If you look at the transcript in my testimony, I testified at the hearing that it's impossible for me to work there and do what's best for children, and I was going to request reassignment down to the civil department. That's in the transcript, and I did make that request, and I was reassigned.
Judge Henderson, is there anything
ma'am.
you'd like to share with us on the Martin Bauer portion of the complaint? What's the evolution of your thinking on that?
Okay. Yes, ma'am. As I testified at the hearing, I think the world of Martin. He's one of the sharpest probate lawyers, adoption lawyers in the state. Martin and I disagree politically. He knows that, I know that. I don't think anything less of him as a lawyer. I don't think he testified. I think the transcript backs up that both he and some of the assistant DAs testified that nothing affected anything that happened in court. I think Mr. Bauer even said that I called him to help out on a tough case after this incident occurred. And that's true, I did. He's an excellent lawyer. What happened is, it's a Friday afternoon at 4 o'clock. I'm not the probate judge. I'm the only judge left in the building. One of his associates comes to seek a signature for filing a new guardianship case. I look at the paperwork. I see that she represents DCF. I see that she's asking the court to appoint Mr. Bauer as a temporary guardian. I say to the attorney, Ms. Mansour, that's a conflict of interest. Representing DCF, you have an obligation to keep down the cost of a guardian as minimal as possible, and yet you're appointing a partner in your own firm. You can't do that. I can't sign this. And she goes, okay, let me call Mr. Bauer. I believe Mr. Bauer testified at the hearing, just like I did. He agreed. It was a conflict. He can't be both the guardian and represent the agency. I told to Ms. Mansour, I says, are you going to let your client know? Your client can waive this conflict. If they're not worried about the cost, or the patient is so difficult that it takes somebody like Mr. Bauer, that's up to the client. That's up to DCF. Are you going to let them know about this conflict? And the answer was no. And I also remember a number
By
of
that
times.
time, you'd already decided not to appoint him, right?
Correct.
So-
Correct. And I said, are you
I'm a
going
little
to?
confused.
Are you not going to let DCF know? You can let the probate judge know. I'm not the probate judge. I'm just the judge in the building for a signature.
So, but at that point, you were asking her if she was going to let them know if she had suggested an arrangement that would have been a conflict, because you had already decided that that appointment was not going to take place.
I did at that
If I'm
moment because.
following.
Yes, ma'am. I didn't mean to interrupt. I decided that at that moment it was because I didn't have a waiver. But I recognize that Mr. Bauer does some of the more difficult guardianship cases, so that if they wish to waive it, that's their prerogative.
Okay.
But she could not tell me it was waived.
And how does all of this relate to the email that was sent?
Right. And then, I don't know if it was the next day, it was a Saturday. I recall every time during the legislative session, if we get an email regarding budget, we're asked to make sure we use our private email on our private time to lobby a legislature. I made the mistake of thinking this is the equivalent, that I wish to lobby the executive branch, and I used my private email on a Saturday and sent the email that I sent. As if you look at the email, I set forth the conflict, and I also say the same thing I told counsel I was going to say to DCF, which was, you can waive it. And then I made the foolish mistake of adding a political commentary on the end of that email. And as I testified at the hearing, I was wrong, and I regret that.
And your personal email address was judgehenderson@gmail.com.
Yes, sir, it was.
So we don't separate ourselves from the office very much. And then you get the follow-up email just a few days later that say they've taken the Martin Pringle firm, a prominent Wichita firm, off their list to use. And my point is less about that than it is if I'm one of these women who say, I didn't come forward for all these years for what the panel called pervasive comments of a sexual nature which were offensive and demeaning. And I'm saying the reason I don't do it is because this guy's A, vindictive, and B, politically connected, and you can write an email on a Saturday and these guys are off the list on Tuesday. I'm thinking I better keep my mouth shut.
I could appreciate that.
And so from where we sit,
Yes, sir.
and with the rule saying that we're supposed to figure out whatever is appropriate, if we don't remove, how do we protect the people who do business in the 18th Judicial District? Because these are bad facts from that perspective.
I understand. The same way I have to, and every judge has to decide who to put on probation or not. You're going to have to decide whether you trust me or not. I know in my heart it'll never happen again. I can tell you that. I mean that. But I can't predict the future. I can't make you any other promises than any other person sitting in my spot can make. I know it won't happen again. That's why I tried to give you the example with my administrative assistant. I take this very seriously. I hope in the balance of things that the positive I've done in my career acknowledge that I wouldn't do something to hurt somebody. I'm not saying what was said was appropriate. I'm saying it was never meant to hurt anybody. As one of my colleagues said, I forgot that I was a judge and still acted as their friend, acted as one of the gang. And I shouldn't have done that. That was wrong.
Any more questions?
I have one housekeeping one. I didn't want to get you off this, and maybe it's better directed to counsel, but you may not know, Mr. Haney. How did the Bauer email come to light? I've read this record, but I never saw anything that said how that part of the complaint surfaced.
I do know, and I can answer if you wish me to, sir. It's my understanding from the investigation that, first of all, I didn't know there was a list. That's in the record as well. I was not aware there was a list. But that email was forwarded from a central office here in Topeka down to local staff, got down to a local worker, and that local worker brought it to the attention of the investigator.
Any more questions? Any further presentation from counsel or his client?
Thank you.
All right, thank you. Court will take this matter under advisement. We now